and what is crime, how it is classified, and what are the classification of crimes that we can see. A person committed an offense is called a criminal. A person who committed an offense is called a criminal. And the person who is liable to be punished as a criminal or is called alternatively accused. A person who is facing accusation of the crime is called an accused. And now the offenses can be classified like this: cognizable offense and non-cognizable. What is cognizable offense and what is non-cognizable offense? 500 ppc. When matter is going to be placed before the concerned police officer stating that, sir, so and so person or A defamed me and circulated about my character and defamed the situation. People are, they have knowledge about this, saying that I have committed this much of mistakes and all this because of such a propagation or bad propagation. My entire reputation has been damaged. Therefore, kindly have my complaint and kindly take it for the commencement of the investigation. In such a circumstances, because it is a non-cognizable offense defined in IPC and CRPC as well as, therefore the police officer has no right to take up any sort of examination, but at least the worst, the police officer can receive that information and he can put into writing into the general diary. Always the police has certain important books in each states are having different names and styles. That is called general diary. In general diary, any information which is being regularly rotated or commenced or executed by the police officers, the concerned station house officer has to reduce into the writing from time to time and minute to minute and hour to hour. That is called a general diary information. In a non-cognizable offense, the police officer or station house officer or person who is in charge of the concerned police station, they can receive the complaint and they can put it into the writing, into the general diary, but certainly they will refer the same to approach and they will advise the concerned complainant to approach for the competent criminal court to take up for the necessary direction for the investigation and all these things. So therefore, in this particular case, we have discussed that cognizable and non-cognizable offenses. So cognizable offense is without warrant the police officer can arrest the accused, and in non-cognizable offense a police officer cannot arrest the particular accused. So therefore these are the two classifications in cognizable and non-cognizable. And whereas and cognizable also, simply we can say that the punishment of beyond punishment is beyond punishment of 3 years can be classified as a cognizable, and below 3, that is called up to 2 to 3 years, can be classified and can be said as non-cognizable. And now the second phase of the classification of offense is that is bailable and non-bailable. As you know, 436 of Criminal Procedure Code deals about the bailable offences, and 437 CRPC deals with non-bailable offences. Well, gentlemen, 436 CRPC, a bail is a sine qua non, a granting of bail is a right for the accused. Automatically, the court has to grant the bail in 436 CRPC covered offences. Whereas 437 CRPC offences, that is non-bailable offences, under which without affording an opportunity to the public prosecutor, a court cannot grant bail. Under some circumstances, the court may or can refuse the bail in non-bailable cases, which would affect the interest of the larger interest of the society. So, however, as we know all, kindly note it, this is more important judgment, Arnesh Kumar versus State of Bihar. Arnesh Kumar versus State of Bihar is a classical judgment wherein Honorable Supreme Court, that is Apex Court, stated that when punishment is prescribed up to 7 years, the 41A CRPC notice shall be and has to be issued to the concerned accused persons, and the notice under 41A CRPC is a mandatory. So therefore, in that particular context, when punishment is prescribed up to 7 years, now accused, the person who is shown as an accused, the person who is described as an accused, that accused has got right to take 41A CRPC notice, under which he can submit his self bond, or he can submit his some guarantee to appear before the police or before court as and when the court calls him for his appearance. So in that particular circumstances, the station house officer or with respect of police to issue a 41A shown and given as one of the accused in that particular case, and CBI, and because of that reason, though Mr. Dastagiri, who himself turned into a approver in that particular 302 IPC case, that because of the statement given by the approver in that particular 302 IPC case, which relates to the then MP who is no more, that is Y.S. Vivekananda Reddy of Kadapa, who represented the Kadapa member of parliament seat. His daughter Sunita Reddy, now she is fighting, and she is saying that because this Avinash Reddy is the responsible. We do not know who is responsible, who is not responsible. For an latest illustration, I would like to give like this, but I can't say that he is the responsible or he is not the responsible, or she is the responsible or somebody is the responsible, because the court has to say all these things. Now I am restrained to speak all these things. But the point is, it is a great research for every advocate. Even Raghuram Raju versus State of Andhra Pradesh case also. That is also one of the great example for the whether in Raghuram Raju versus State of Andhra Pradesh case, where the Lordship of Andhra Pradesh High Court as well as in Supreme Court also, they stated that even without approaching the Sessions Court, aggrieved or the victim can directly approach the High Court of Judicature for an anticipatory bail. That is the special dicta decided by the Supreme Court as well as the High Court of Andhra Pradesh. So why I am saying is, in Y.S. Avinash, in this Y.S. Vivekananda Reddy murder case also, this CBI alleged that Y.S. Avinash Reddy is the responsible. How the CBI stated like that, because of Google takeout information, they have collected the all material by what time and where while the offense was committed, where was Mr. Avinash Reddy, where his presence was available, how he was present, whether he was present very near the offensive place or not. All these information was collected from the Google takeout. So this is the great example in an Indian judiciary or in an Indian investigation system. A person, even the eyewitness was not available, nobody can escape from that particular scene. So this is one of the example. One can understand the situation of the Indian investigation system and Indian law system. Therefore, I can say, my dear friends, in Raghuram Raju versus State of Andhra Pradesh case, the Honorable Apex Court as well as Andhra Pradesh High Court categorically stated that an anticipatory bail can be moved before the High Court of Judicature under Section 482 read with other criminal procedure code system without approaching the Sessions Court. There is a feeling in every advocate mind whether without approaching before the Sessions and district, can we approach before the High Court of Judicature in the respective states for the getting of anticipatory bail? But the answer is Raghuram Raju versus State of Andhra Pradesh case is a classic example to that particular query. And the second aspect is how the investigation system, and even without the presence of the, why I am saying all these things, in a 304A case, I am again going back, in a 304A accident case, nobody did not witness the incident, but the cameras, which is always fixed in the particular area. You may put one question, sir, no cameras are there. What could be the next position? Even in one judgment, even tire marks in the particular area also is one of the important crucial point to find out the crime vehicle. In my career, now I have finished my 31 years experience. Now I'm running 32 years experience. While I was in fifth year advocate, I took this challenge. Why? Because one accident was committed by some X, but that X was escaped. But police, in a brutal way, or because of the reason of political influence and all these things, they implicated a case against my client, under which I investigated and I inquired about the incident. My client stated that, sir, by that time, I was in Hyderabad, sir. With which vehicle? The very same vehicle, the police under which the crime is registered, that vehicle was available in Hyderabad, wherein the police brought that vehicle and cooked up the case. Then we have produced all the toll gate informations, all the toll gate informations, all the toll gate receipts, and all the toll gate cameras, clippings, and all these things. Ultimately, we have proved. Of course, saying is very easy, but in a execution in a practical way is quite different. It took up for me not less than 2.5 years to collect all these things, to summon the witnesses and everything. Then
ও কি
ultimately
আছে ডলু এখানে?
proved that the alleged innocent accused
ও
did
বাচ্চা
not
ছেলেটা কি
commit
আছে?
that offense.
ডলু
My
কি আছে
God,
এখানে? হ্যাঁ?
you please take care of everything while a fresh matter come to your chamber. Suppose if you are a raw junior, don't feel any shy. See, no one is an encyclopedia Britannica on this earth.
হ্যাঁ।
You all people are analytical, ethical, perfect, loyal, royal, powerful,
ঠিক বলেছো।
peaceful personalities, I believe. Why? Because everyone is definitely a raw person when he intends to start his practice on the first day. But doesn't mean that he won't succeed. He would succeed if he works hard. So in this particular case, what I would like to say is the jurisdiction of the courts. How the jurisdiction can be decided. Say for example, an accident was occurred within the limits of a police station, and the vehicle passed away, and the vehicle was ultimately found and identified in the next district, and a communication was went on, and that was caught hold, and even in that particular area also, on that information, even though the police officer has no power, he can register a zero FIR saying that, knowing the information, because in a police set, the communication was circulated by the entire police, or the police will circulate the entire information to the entire police. Say for example, in a police station area, accident was committed by B driver, but he escaped from that particular place, and he left the district, and he entered into the next district, and in that particular district, when the police officer who received that communication, he has got every right to register a zero FIR stating that I received an information through police set information saying that so and so offense was committed at so and so police station, and therefore I found this particular vehicle relates to the so and so crime. Therefore, I am registering a zero FIR saying that so and so driver committed so and so. On a confessional statement given by the driver, also the particular police officer can write a zero FIR. That is called a zero FIR. Zero FIR means the police officer who has knowledge about the information, he can register the zero FIR. That zero FIR along with that vehicle, that crime vehicle, he can transfer the same from his police station to the police station where originally the offense was committed, and that is called as the transferor police station. The transferor FIR goes to the transferee police station, means where the real offense was committed. Then the police station in whose jurisdiction the original accident was committed, that police officer, after taking this zero FIR, he starts to write this particular FIR at fresh, saying that so and so zero FIR received from so and so police station with a crime vehicle where the accused committed so and so offense because of that reason so and so person died in the particular accident. So in that particular circumstances, the original jurisdiction police officer, he would register the crime against that particular driver who committed the offense, and he will start his investigation. So this is the way how the jurisdiction, how can we fix the jurisdiction? Say for example, in a 379 IPC case, it may have case. Say for example, our friends are, suppose our neighbors went to the America, and say for example, I am staying in Mumbai. Yeah, my neighbors went to America, informing that brother or yeah, I went to America. I mean, we are going to America like this. There, then after some time, an offense was committed my neighbor's house, stating that some robbery was committed by some unknown. Then that information was received by that particular American people, when the person who left to America, and they communicated the same thing or something. But the very first information is received by me or identified by me. That's me. I have right to go to the police station and I can lodge a complaint before the police, even without waiting for the real victim people. I can lodge the complaint, and that complaint has to be received by the police officials. In that particular case, I would be the first informant to the particular police. Then the police will commence the investigation, and after receiving the FIR from me, which is going to be duly signed by me, and the police will start the investigation. And after recording my statement and the FIR and all these things, the concerned FIR will go to the court where the police station is situated, or the court which is having our superior power or administration of justice power over the police station. That police officer will send the FIR to the particular court, and he sends all the FIR other copies to the all his officials. So in that particular case, after sending the FIR, the investigative officer starts the investigation always, and he always visits the particular scene of offense, that is the house where the offense was committed. And in that particular case, for getting of fingerprints and all these things, the clues team will the clues team will be bring by the particular police, it will be called by the police officials, and the clues team will come and find out the DL system and any fingerprints which are available, or the offensive items which were said to have been left over by the particular accused. Then the clues team will find out. Then the investigative officer prepare the rough sketch. The area where he visited, he will draw the rough sketch. So then he will record the statement, and he will record the photographs. Nowadays he will record the videograph and all these things. And after that he will call the even that American that American people where they reside, or they can be examined even through video conference. But in 164 CRP or 161 CRPC, they can be only recorded under any mode, but 161 CRPC statement cannot be used as a direct evidence. It can be corroborated and contradicted, and an opportunity would be given to the accused to facilitate him to challenge the evidence which is going to be recorded under 161 CRPC. The statement said to have been recorded by the police officer under section 161 CRPC, always the police officer reduced into writing, and finally in last line, I have explained the statement recorded by me to the deponent who gave this. But in 161 statement, the police officer has no right to take the signature of the person who intends to give statement to the police. This is more important, my dear friends, remember. In 161 statement, if any police officer takes, or if any police officer take any signature on the beneath of the 161 statement, that 161 statement has no evidentiary value, remember that. But whereas 164 CRPC, that is a statement which is going to be given by the victim or the person who have knowledge about that particular incident, that can be recorded before the competent magistrate, or that can be recorded by the police officer in the presence of the competent personalities or in the presence of the particular witnesses. Then that can be 164 CRPC is a different format, 161 CRPC. and 150, I can say is in particular, again I'm going back, cognizable and non-cognizable. This is very, because the crucial point which I wanted to say is, in a cognizable, the police officer can take up the investigation. In a non-cognizable, what is the fate of the particular individual? In non-cognizable case, the victim or the complainant has to approach before the competent magistrate who has jurisdiction to entertain or to take up the complaint, and he has to submit his complaint under 200 CRPC coupled with 156 class 3 CRPC. 200 deals with the private complaints before the magistrate, whereas 156 class 3, a magistrate is empowered to send the complaint to the nearest police station for the investigation. So if magistrate feels that the investigation is required even in a non-cognizable case, even though the victim submits his complaint before the court, under section 156 class 3 of CRPC, the magistrate can refer that complaint which is said to have been submitted by the complainant to the concerned particular police station, and he can order and he can direct the concerned police officer or investigative officer to investigate into, to register the FIR and to investigate into if necessary. So that order would be passed in non-cognizable cases by the magistrates under section 200 and 156 clause 3 of CRPC. Even in sometimes, even in cognizable case also, even though the police officer is empowered to take your complaint, because of various reasons, police officials won't take up your complaint, and police officials won't accept your complaint, and police officers simply neglect to register the case. In such a circumstances, what we have to do, or what shall we do, and what do? This is, if victim intends to file a complaint in a cognizable case, it is the duty of the police officer mandatory that he has to take up the complaint. But in another reason, the police officer does not interest to register the case, then what is the, in that circumstances, the copy of the complaint always keep with one copy of the complaint. Advocates have to suggest their clients, or advocates who would like to file a complaint on behalf of the complainant or victim, they should take a duplicate copy with them. Always they should retain a duplicate copy with them. The original always submits, always the complainant submits original complaint to the police, always, and the duplicate copy always keep with the party or retain with the party for further course of necessary action. And the duplicate copy which retains with the particular complainant or victim, that copy has to be, or that information has to be sent to the district superintendent of police, and with that you can request the competent superintendent of police and request him to take up necessary investigation according to the CRPC. In that particular aspect, the superintendent of police, if he feels that there is a point to go for the investigation, suo motu, the SP can take up the investigation, or else he can guide or direct his subordinates to go for the investigation of the case. Even after sending the case to the SP, even after SP referring the complaint to the subordinates, still the grievance is not solved. What would be the result? Then the victim has to approach before the competent criminal court by way of filing 200 CRPC private complaint along with necessary affidavit under rule 37 and 38 of criminal rules of practice. These are the facts. Under these circumstances, I have lodged a dismissal of complaint on so and so date. But the concerned police officer did not take up the investigation. And later I requested the SP to take up the investigation according to the CRPC. Even then SP also did not take up any investigation. So under these circumstances, the justice is required. So therefore, I am approaching before the honorable court to take up the matter for the taking of the cognizance of the case, under which if the case of the complainant is right, after taking the evidence, a oath or something from the witnesses, the Honorable Court, if finds that there is a point to proceed further, then they will issue summons. So this is another procedure. So my dear friends, how to file the FIR? We have experience with 302 IPC case and 279 IPC case. We have discussed. I mean, 279 is a rational negligent manner. All this is the 279 and all these things. And 337, 338 relates to Act 337, I 338 and 304A, and 279 IPC relates to accidents and rash and negligent acts, and 323, 324, 325, 326 relates to offences relates to human body, and offences relating to matrimonial disputes 498A and 304B, specifically 304B IPC, and furthermore 350 offense against women 354, 354A, B, C, D, and 379 IPC, and offences relating to the waging war, we want to the criminal conspiracy is 120B, and 499 and 500 is related and discuss about the defamation and all these things. So these are the IPC related crimes. And now we have to see other than the IPC. Let us see Narcotic Drugs and Psychotic Act, that is NDPS Act, as we know all very well, because nowadays the drug activities are rapidly growing up, and drug offenders are being arrested time to time by the concerned police, and some innocents also being arrested, and some real culprits are escaping from the calamities and all these things. So in that particular case, recently I was fortunate. I argued before the High Court of Judicature in Ranjit Singh versus State of Andhra Pradesh. Ranjit Singh versus State of Andhra Pradesh. Generally, as and when a ganja, this cannabis, this suppose finds from anyone, simply the police register the case under Section 20 of NDPS case, and they send the all culprits to the they submit, and they produce all the culprits before the courts. But here, the quantity of the cannabis which I found in the particular FIR, because the commercial quantity, if it is commercial quantity, then the punishment is a different, and below the commercial quantity, that punishment is a different. So in that particular case, my client arrested below the commercial quantity, but he was sent to the judicial custody, though he did not commit more than commercial quantity. So in that particular case, I argued the matter. The property involved in the seized property of cannabis relates to my client, that is Ranjit Singh. I have argued before the High Court of Judicature, stating that that is worth value of one case. So therefore, 41A CRPC would be applicable. That I have argued. This is a reported judgment. Even my friends can see my name, that is as Dr. Majjusuri Babu, counsel for the petitioner in that particular bail application. In that, the Lordship's Court of Andhra Pradesh held that even in NDPS cases, if the punishment is prescribed to that offence up to 2 years, because it is a fallen under the category of Arnesh Kumar versus State of Bihar, where the apex court held that when the punishment is up to 7 years imprisonment, certainly this Ranjit Kumar is entitled to get the bail. Therefore, the gentleman was released from the bail from the judicial custody. This is a classical judgment, wherein the judgment is being adopted and applied and taken into consideration in various cases in the total national level. This is a fortune in my life. So in that particular case also, let us take it as an example. See, advocate must read the entire recitals of the complaint. Suppose if you are a defense counsel, sometimes advocate represents for the complainant, and sometimes advocate represents from the accused. So two-way folded lifestyle and two-way folded duty has to be discharged by the advocate. So when we appear on behalf of the complainant, what type of measures to be taken, and when we appear on behalf of the accused, what type of defense has to be taken, that has to be always kept in the mind of the advocate, because the dual role of the advocate uh, always plays an important role for the success in getting or in protecting the interest of the respective claim. Now let us see. Suppose when we appear on behalf of the complainant, naturally
চুপ
the
করো,
victim,
পড়ছি।
he always narrates certain important facts, or even sometimes the complainant represents unconnected facts to the particular case. Then you have to evaluate and you have to investigate, and the counsel who would like to take up that bundle from the complainant or from the case, how to prepare a complaint is a basic skill, and that is a drafting skill of the advocate, which is a prima facie more important. For example, in 379 IPC theft case, suppose if the value of the property does not mention by the complainant in his complaint, where is the complaint? How the police can recover that property? How the police can investigate that matter? And if the description of the property is not properly given, or else if the attached documents relates to the ornament, suppose if the ornaments purchased from a particular jewelry shop, naturally we keep always the receipts. If the receipts are not available, then that doesn't matter. That is a different aspect. That drafting skill is a different. Suppose whatever the evidence and whatever the documentary evidence and whatever the eyewitnesses available with the complainant, the drafter of the complaint must prepare all the necessary ingredients on behalf of the complainant in the manner of the first person. Always, the complaint must be in the first person if the complainant intends to submit his complaint. He cannot represent as a third party complaint. Complaint always drafts by the complainant or his henchman or his follower in the first person only. It cannot be like the second person and third person style way. That style is not at all perfect. Like suppose for example, like an affidavit, how the affidavit is going to be drafted, in what manner the affidavit is going to be drafted, in that line the complaint always draft always draft in that manner only, in second person and third person language. In a local language also, the first person language always used by the complainant in drafting a complaint. So my dear friends, when it comes up from a defense, naturally defense you need not worry about that, because the other side will supply the other side has to supply the necessary documents under which they depend, and under which they intends to go for the continuation of the prosecution on behalf of them. Naturally sometimes defense is easy rather than the complainant side. Why? Because naturally in India, and always the innocence is cardinal principle in the Indian judiciary system. The benefit of doubt maximum extends to the accused. The benefit of doubt always applies to the accused, and the crime or the offense or the allegation always prove beyond all reasonable doubt by the prosecution to prove the guilt against the accused. Whereas in US arteries, it is the duty of the accused, he must prove his innocence. The complainant need not prove his case. But whereas in India, the complainant has to prove, or the complainant or the prosecution has to prove the case against the allegations or accusation against the accused. And always in Indian judicial system, the accused is always an innocent person until the guilt is proved. So therefore, the defense is very easy rather than the prosecution system. That is the thought process which is being always spoken by the all advocates. It is not right. Always prosecution is highly problematic, and the conduction of the defense also is always a problem. And a challengeable complainant side also is a challengeable, and accused side is also challengeable, and both ways are a tough situation for the advocate, because the advocate must understand the case carefully The advocate always should read the complaint carefully and witnesses and statements carefully, and the way how to conduct the simple I would like to give a simple analysis. Prosecution side, for example, victim goes to the police station and files his either written complaint or gives his statement. Then police, if he submits a written complaint and he the same ingredients incorporate into the format which is under section 156, that is called first information report, and the original report attached to that particular complaint, that is the first information report. Suppose if the witness doesn't know or the informant doesn't know with regard to the writing of the complaint, then the police officer always records the statement which the victim intends to submit the same, and that always explains into his own language, and the police officer always takes the personal signature on the particular complaint. Then the investigation starts. Then with that complainant, suppose if many witnesses are available, the police officer in a cognizable case, remember in a cognizable case, the police, after registering the FIR, he records the statement under section 161 CRPC. Naturally, the complainant complaint is nothing but a replica of the 161 statement, but the replica of the 161 statement contains recitals as well as the FIR original complaint or original statement, always one and the same. Remember, this is very important, a crucial point for a criminal advocate, a defense advocate. Then, suppose if the complainant brings his witnesses by the time of presentation of his report, then the police officer always records the available witnesses' statements under section 161 CRPC statement. But on that 161 CRPC statement, the police officer has no power to obtain any signature of the witness or the informant as in 161 CRPC. But whereas in FIR, first information report, the signature of the informant column or the signature of the complainant column, there the complainant always signs or always puts his thumb impression if he is any litigated person. This is the fundamental information. Remember. Then all columns, you please go through once the FIR copy if you have an opportunity. Then date of offence, time of offence, place of offence, name of the informant, section of law, and all these columns are inserted in the first information report of the particular police station. Then the crime number gives by the police officer on the FIR. Suppose, for example, crime number 20/23 registered on so and so. On the strength of on the need of the complaint, on the need of the FIR, after obtaining the signature or thumb impression of the complainant or informant, the police officer, after registering the FIR under section so and so, I registered as case in crime number so and so. I registered the same, and the original FIR is forwarded to the concerned magistrate, and copies are forwarded to the higher officials. This is the endorsement always endorsed by the person who registered the case or who endorsed the information on the first information report. Therefore, in that particular case also, the defense advocate always observe like this. Is there any delay in giving information? Say, for example, offence committed or offence done by the particular person on 5 days back, 6 days back, 8 days back. But logically, complainant did not approach the police station. The reasons best known. After 10 days or 15 days or 20 days, complainant intends to file a complaint. Then, really, if the complainant receives any injury from the act of the alleged accused, he ought to be present the complaint in time. But he doesn't do so. Therefore, there was some doubt. So therefore, in that particular case, inordinate delay in giving information is a bad thing to the prosecution case. The category of the judgments are there. If you click in the Google, inordinate delay in giving the information to the police by the informant or complainant is a fatal to the prosecution case. This is one of the most first fundamental defense always maximum advocates takes and brings before the court. So therefore, inordinate delay in giving information or else inordinate delay in lodging report before the police is a fatal to the case. Suppose if the complainant explains the reasons for the delay, then if that delay is probable and if the delay is believable, then that is the point to be considered by the court at the time of passing of the pronouncement of the judgment or at the time of passing of the any order. That is a different aspect. But the defense always, the counsel always takes the defense that whether any delay occurred in lodging the report or whether any delay occurred in giving the information to the police. This is very cardinal principle, very first defensive point to be applied and has to be taken into consideration in the mind by the counsel who wish to go for the defense. Then registration of FIR in prosecution way and defense way I am explaining. So after registration of the complaint, then after recording of the statement, the police, the investigative officer who intends to take up the investigation, he always visits the scene of offense. What is scene of offense? The place where the offense is called is scene of offense. Remember, the place where the offense is called scene of offense. So, for example, accident was occurred at 10th milestone at some Bombay highway at some particular town by name, which is distance about so and so kilometers north or east or west or south to the police station. Suppose, for example, Ramnagar, 10th milestone, right side, accident was occurred. Then the investigative officer goes to that place and he visits that place. That place is called, where the offense is called, that is called scene of offense. Then the scene observes by the investigative officer. Then he prepares a rough sketch. After observation made by the police officer, he prepares scene observation sketch. That is called rough sketch. Rough sketch of the scene of offense. So, investigative officer visits the scene of offense and he prepared a rough sketch. That rough sketch is called scene observation sketch. Then he prepares it. When he prepared a report, that is called scene observation report. Remember, there are 3 stages happens at that particular place. One is visits the scene of offense, and number 2 is after visiting the scene of offense, he draws the rough sketch of the scene of offense, the offense where the incident, where the place where the incident is occurred, that is called scene of offense. Then after visiting the scene of offense, that observation is called as a scene observation, and in that particular case, naturally and always the investigative officer always does like this. He prepares a rough sketch and he prepares the scene observation report. So one is rough sketch and another is scene observation. In that particular case, always he does that activity in the presence of the independent mediators, saying that I have visited the so and so place on so and so day and visited the scene of offense and observed the scene and taken the rough sketch and prepared the scene observation report in the presence of the independent mediators. Why the independent mediators are required in this particular case? If the independent mediators are not produced, are not recorded, are not mentioned in the particular report, then it vitiates. Why? Because it would go for some suspicious circumstances. Then that would be called as a table investigation. Sometimes police officers, they don't want to go to the scene of offense and they don't want to prepare any rough sketch and they don't want to see any scene observation area. Simply they prepare always, maximum police officers, 60%, 50% of the police officers, they prepare everything in the police station. That is called a table investigation. Remember, my dear friends. That is called table investigation. Means without going anywhere, simply creates everything saying that I went there, I prepared this much and I prepared that sketch and I taken all these things. And even mediators also, they put their signature in the police station. They are called as stock mediators. Remember, my dear friends, the mediators who always they have to act as and when the real things happens. But here, the created and illusory mediators and arranged and set up mediators were prepared or being developed in the criminal justice system. I mean, the police administration system. They always bring some artificial or the I mean persons who did not really witness that incident. They would like to keep them as a independent mediators, and in that particular sense, the defense advocate has to take up a very crucial, important point. In this, what I wish to advise to all my friends is always you please, defense witness, please visit the scene of offense area, because the visiting of scene of offense area would give volumes of truth to the every advocate that would be benefit for the succeeding of advocacy. Why? Because suppose sometimes if the mediator comes up to the court saying that I witnessed the rough sketch drawn by the police, but when you put a question like this, really by what time you went to the scene of offense? When did you start to go to the scene of offense? How many persons started from the police to visit the scene of offense? How many persons boarded in the jeep to visit the scene of offense? How many persons gathered in the scene of offense? What did you identify in the scene of offense? Who informed about the incident scene of offense? Who prepared the rough sketch at scene of offense? And who drawn the rough sketch at scene of offense? All these questions, if really the if the mediator who set over and produced before the court, if really doesn't witness the incident, definitely he would fail to give all these answers. Then the defense would succeed in that manner. So, my dear friends, defense always must take careful to visit the scene of offense area, and they must they also observe the rough sketch, and they should tally the points which are drawn by the concerned officials. So this is scene of offense questions. So FIR questions I have given, then scene of offense questions, rough sketch questions, and other important mediators questions also I have. And inordinate delay in lodging the report and delay in giving information report to the police, the defense points. And now let us see how to cross-examine the witnesses of the prosecution. The person who filed a complaint is called the informant, or is called as a listed witness 1. And LW1 and LW2, the police officer, after recording the statements and after getting the now I am discussing about the prosecution. Now we have discussed the defense. Now I am discussing about the prosecution. After recording the statements and after collecting the necessary material, and after collecting any incriminating material and any material objects in that case, and summarize the entire case, and prepares a charge sheet, and after enclosure all these 161 statements, first information report, and mediator's report, and Panchanama report, and rough sketch and other things, the police, they file charge sheet before the competent court, and the competent court take up the cognizance of the case and issue summons to the accused, and the accused will appear before the court, and the accused will be examined under section 251 CRPC if it is a summons case. Otherwise, in warranty case, the procedure will be followed in a definite. And later on, after denial, suppose if the accused is going to be admitted the case, he will be sent to the he will be punished. But suppose if the accused denied his offense, saying that he intends to claim for trial, then the commencement of trial will begin. Then the summons will be issued to the witnesses, that is listed witness 1, listed witness 2, listed witness 3. Now always generally the informant would be called as LW1. Then LW1, when he comes into the witness box, then he will be called as prosecution witness 1. That is called PW1. So always the judge writes like this. LW1 examined as a PW1, his statement or FIR marked as exhibit P1. Prosecution side in criminal case, there are the exhibits always marks like this. Prosecution examination exhibit P series take up as a P series. Suppose if any document marks on behalf of the prosecution, exhibit P1, one document. Second document exhibit P2, third document exhibit P3, fourth document exhibit P4. Like that, prosecution witnesses series are like this. And suppose any material object, suppose any offensive item, suppose in 324 case, a beaten with a stick, then that stick is a offensive article used by the accused during the course of commission of offense against the victim. Then the police always recovers that weapon at the instance of the accused confession statement, or after showing the necessary article by the particular victim, then that would be called as a material object. So the objects which used in the commission of crime, which were recovered by the police during the course of search and seizure procedure under 100 CRPC, then that is called 100 CRPC, that is called search and seizure procedure. So then marking would be like this: material object 1, material object 2, material object 3, like this. Suppose if the defense items intends to be produced or intends to be marked by the prosecution, then that would be marked as D series. Suppose if the court voluntarily, if the court intends to mark certain documents sumoto by the court, then X series would be marked. So, my dear friends, remember, prosecution examination LW's listed witnesses. If the listed witnesses comes into the witness box and if they examined by the court, they would be converted as a prosecution witnesses 1, 2, 3, 4 serial. And material objects, if any used in the commission of crimes, that material objects always marks like material object 1, material object 2, material object 3. And likewise, suppose if the court intends to mark sumoto or voluntarily, then that marks as a exhibit X series. And suppose if the defense intends to mark their version, then that would be marked as a D series. Then coming to the examination of the witnesses, the prosecutor would examine the witness who are supposed to be examined on behalf of the prosecution. Then chief examination records by the court, which is going to be submitted by the prosecutor witness. Then chance will come to the defense. Then the defense has to read the entire 161 statement. The statement which is recorded by the police, if the witness confronts the same, that is called corroborate, that is called as it is. But beyond the statement, suppose if the witness intends to give, that is called improvements of the statement. Improvements of the statement. Say for example, the victim stated like this. According to the original complaint, victim stated that at 7 p.m. morning, accused came to my house and he brought one stick and bet on my head and I received bleeding injury. This is a complaint given by him. Whereas in the evidence, for exaggeration of his case, if victim says accused came to my house at 8 a.m., bet with the iron rod and I received injury on my forehead. What are the improvements? Time of the offensive time, the crime time is changed, the weapon used by the accused is changed, and the injury sustained by him is also changed. So remember, my dear friends, you please go through what are the recitals of the complaint consisted in the complaint set to have been submitted by the complainant. This is very, very important. So the time of offense, date of offense, recording of evidence, and the alleged recovery, if any, shown by the police, the time of recovery, or the witnesses who are said to have been present during the course of recovery, those important points always put to the cross-examination of prosecution witness 1, that is very, very important. Suppose if the witness goes beyond the statement, that amounts to contradiction. The statement which he stated, if he doesn't speak the same before the court, and beyond that statement if he gives, then that portion of the statement is how to put like this. You have not stated before the police that at about 8 a.m. so and so person came to your home and bet with so and so weapon and received injury on your forehead. Because the version in the complaint is a different and the deposition given by the witness is a different. So when the deposition is a different, that portion you have to put forth before the complainant saying that you did not state before police like this. Then witness will say like this, no, I have stated like this. Then that would be recorded by the court as it is not true to suggest that I did not state in my 161 statement that at about 8 a.m. the witness brought so and so weapon and bet with that on my forehead like this. The very same question you have to put to the investigative officer at the time of his evidence in cross-examination saying that whether the PW1 stated like this or not. You have to put the entire question to the police officer whether the PW1 stated in his 161 statement that so and so accused came to his house at 8 a.m. with so and so weapon and bet him with so and so. Naturally, the police officer would say that no, he did not state before the like this. Then that is called an improvement. So that improvements are very much important. Then that evidence consisted with different contradictions. So improvements of the evidence has to be confronted. Contradiction of the evidence of the witnesses have to be confronted by the defense, and those contradictions and improvements of the evidence have to be confronted and put the questions to the investigative officer who set to have recorded the 161 statement. Because the 161 statement is a cardinal document either to contradict or to corroborate. So therefore, this has a dual value for both defense and prosecution. So in this particular case, my dear friends, you please take care while you conduct a case on behalf of the defense side, or when you intend to go for the prosecution side also, you must take more care. And coming to the appreciation of the jurisdiction point, where the offense is committed, there the jurisdiction has gone. Suppose if the offense is committed at a particular place, say for example, Section 6 of the Indian Evidence Act, you please take up. Section 6 of the Indian Evidence Act is a res geste. For example, a waging war against the government was planned at Pakistan, at Lahore. Then money was transferred from Lahore to Delhi, and that money again transferred to Kashmir. And at Kashmir, some logistics, some atomic material was purchased in a Kashmir local area, and thereafter that material was sent to the Hyderabad, and later on that Hyderabad weapons were transferred to the Andhra Pradesh, and thereafter from Andhra Pradesh, from Hyderabad to some other from Hyderabad to Andhra Pradesh in Vijayawada, they have transferred some vehicle. Then where the complaint has to be referred, a police officer can register anywhere, because the forum part of the same transaction, the police officer who investigates, who finds a crime, they can register entire in any place of the offense, they can register the case. Likewise, suppose in a 323 IPC case, say for example, in a Shirdi village, 10th Street, at the house of A, offense was committed like this. A attacked B. Then complaint has to be lodged in the concerned town police station. Because Shirdi has got two police stations, for example. Rural police station consisted with the rural areas, and the city police station consists of the city police station. If the offense is committed, because offense is committed in the city limits, the city police or town police station has got right to register the case. Therefore, the complainant has to approach before the town police station. He cannot approach the rural police station to give the complaint. So, the complaint where the offense committed, there the complainant has to approach in the concerned jurisdiction. And regarding the court fees and all these things, I need not explain, because the stamp duty, and always you need not go for that in a criminal cases. Even for wakalatnama, you have to go for advocate welfare stamp. Even for every other stamps, you have to put 1 or 2 rupee stamps like this. For that good fee, you need not bother about it. So under these circumstances, my dear friends, it's a very great fortunate moment for me to interact the first day session, and I'm very much thankful to the organizers who